You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument.
Our guest today is Alan Hamilton of Shiver, Hamilton, and Campbell over in Atlanta, Georgia. And I've had the privilege of knowing Alan for a little while now and watched he and his firm go from being very, very successful to extraordinarily successful. And he was kind enough to let us borrow some of his time today and come on the podcast. So Alan, thanks for coming on.
Thanks for having me.
Yeah, man. For folks who don't know you, will you tell us a little bit about who you are and what you do?
Sure. I'm Alan Hamilton. I live in Atlanta, grew up in Alabama, but I've been here now longer than anywhere else in life. That's a function, I guess, of no longer being a young lawyer and being now a middle-aged lawyer. But my partners, Jeff Shiver and Scott Campbell and Kyle Wallace, and I have a firm we've got 9 lawyers. We're based in Atlanta. We're really all over the state. And I've litigated cases in about 20 some odd states, but based in Georgia. Most of our work is in Georgia. We'll travel for the right thing anywhere. And we did a single event. Go ahead, Kenny.
I was going to say, y'all have done a lot of complex stuff. I mean, you were mentioning single event, but a lot of the single events y'all have done, I mean, from what I've seen, it's everything from, products to negligent security and all points in between.
It's just about everything that's catastrophic single event. We do a little bit of medical malpractice, but not much. And that's probably the most limited subject matter area. But from workplace explosions, we've done a lot of those kind of cases for whatever reason, cases where there's third-party liability navigating around the comp bar, auto product liability, other types of product liability. It really has run the gamut. It's been a very interesting practice because you're always learning about something. I'm working on a case where a bridge collapsed during demolition construction now. So just as one example, there's never a dull moment. You're always having to become somewhat of an expert in something you previously knew nothing about. And that's one of the challenges, but also something I think keeps it very interesting and meaningful.
It does. I mean, for me, who's someone who's not scientifically inclined, mechanically inclined, engineering inclined, the fact that the amount of science, medicine, engineering, and physics that I've had to learn over time, it always shocks me, I think, more than anybody, including my dad, who's like, man, good job, son. That's right. Surprising.
Right.
We're talking today, a lot of our listeners, a substantial portion of their practice involves auto cases. And y'all have had a lot of success on looking at an auto case where the damages are catastrophic, but some folks might not see anything beyond the auto insurance policy and the auto insurance limits. And y'all have been able to establish additional defendants, uncover additional policies in a wide range of different directions and areas. So just kind of tell us a little bit about some of the examples, and then we may dive into each more.
Sure. So, I mean, like your listeners, I the best cases are auto cases where you don't have to look for other more complex theories, right? But that's a combination of where fault lies, at least in an apportionment state like Georgia, and many others, where ultimately the jury will be able to place percentages of fault on entities, parties, non-parties, whether you sue them or not, as well as insurance coverage, of course. I mean, if you've got a big enough case and inadequate coverage, and especially if the carrier is going to pay it if you give them the chance to, you really are left with no choice. If you want to get full justice for your client, you really don't have a choice but to explore every other possible angle. And so just over 20 years of doing this, I've seen and been down. There's always a new road. I mean, I find something new every year that we haven't done before, but we've just explored, if not many different angles to look at when you got a serious or catastrophic injury product liability case. I thought you and I could unpack some of that today.
Yeah, so your process, your firm's process, catastrophic auto case comes in, and again, on its face, it may look like there's just one defendant, uh, just one insurance policy, but there may be a products component to it. What are y'all doing to identify potential vehicle defects or heck, even things involving, we'll say specifically the tires?
Sure. Well, we'll start with products. Sometimes product cases are on the spectrum relatively easier to spot. I mean, one of the things that you want to see in an auto products case is, especially if there's multiple people involved, is one person injured much more grievously than others, and why? So examples of that, we're looking at a roof crush case right now where you have the classic type injury pattern. And if you don't know this stuff yet, it takes some time to learn what the injury patterns are that fit a particular type of defect and what to look for. But really, to make it as simple as possible, if you have a crash that should be survivable and somebody either didn't survive or has grievous injuries, then you ought to be looking at whether there's any kind of crashworthiness failure. And even one step further back, we talk a lot in our firm. We borrow the medical jargon of triaging cases. So and as you know, doctors talk about it, and I think it's a useful way to talk about a lawsuit, is a differential diagnosis. You've got to learn and study and talk to enough people and frankly get enough experience to where you even learn what all those possible diagnoses are. But to get it back to the auto world, the diagnoses are all the possible ways that things that contributed to cause the injury. So when you're talking about a crash and a product case, there's two big categories of defects. There's defects that cause a crash, and there's defects that enhance an injury. So the first kind, a classic example is, a vehicle that, like, think of the CJ Jeeps way back in the day that are easy to roll over, and there still or the Ford Explorers in the 90s, all the cars that roll over and cause a crash. That's a stability or handling or rollover propensity defect. So, and then there are many others, but those are kind of the classic ones you think of. So if you have a rollover case, you've got to be thinking, where did it happen and why? So you've got to unpack the reconstruction very carefully. What caused the vehicle to trip? Is it a vehicle that has, generally speaking, a high rollover propensity? Are there other cases out there like yours against this vehicle alleging that kind of a defect? And then critically, what caused it to trip and roll? The more it is on the pavement and not, going off the road or striking some object that shouldn't be there that could cause the roll, the better. And then in the other category of defects you're looking for, you want to figure out, is there something that the vehicle failed to do or did that caused the injury to be worse than it should? So significant crashes where an airbag didn't go off. I mean, airbags are universal in vehicles of the last 10, really 20 years. So if you have a generally frontal, let's call it on the clock face, 10 to 2 kind of crash, and it's significant forces at all, and the airbag doesn't go off, then you ought to be at least considering why. And you can download the box, the airbag control module with a qualified reconstructionist or other expert and take a deeper look at that. But then you also have to match up with, I've had many calls from clients who have all kinds of bad orthopedic injuries, and they say the airbag didn't go off. And first of all, for auto products, you got to have catastrophic injury or it's really just a non-starter. Needs to be death, paralysis, or something that's really significantly long-term limiting. And I don't mean like in a car crash case where we talk about how a lumbar spine surgery is long-time limiting. It is, but that's not what I mean in the context of having damages worthy of pursuing the complexity and expense and risk of an auto products liability case.
Thank you. On the when it comes to the crash worthiness cases, what do y'all look at in terms of things that where it's likely survivable, but in this instance wasn't, versus, man, it was so bad that even despite their best efforts on crash worthiness, this person, God bless them, just wasn't going to make it, or was probably going to sustain a similar, if not identical, injury, even if the car was better made and was more crash worthy.
Great question. So, I mean, it's good to have good biomechanics or other medically trained people to help you look at the medical records. And over time, we can know to a decent degree of certainty whether it's something to pursue. You start with, though, how many people were in the car, and did some of them essentially walk away or have modest injuries? So we're investigating a Ford pickup truck rollover with a roof crush that left a client as a C2 quad, and two other people in the truck walked away. And that is a function of the way, and it's a problematic truck from a roof strength standpoint. So you also have to, Google can do a lot for you. Talking to other lawyers can do a lot for you. Call in lawyers who do auto products, whether you're going to refer the case or not, to just kind of start to piece together, is this a known defect? Is this a problem vehicle in this aspect of its design? But when you look and you have multiple people in the car, it's a significant clue that you may have a crashworthiness issue when there's a huge disparity in injury, one to the others. Fire cases is another example. I mean, you've got to figure out as best you can oftentimes fire cases are death cases, and a post-collision fuel-fed fire. An old, great engineering principle is you ought not be able to survive a crash only to burn up in your car. So the fuel systems, in other words, should be designed so that they don't rupture and start a fire in a survivable crash. If a crash is bad enough that nobody could survive it, might you have a fire? Sure, that's sort of the point. But there are ways you can forensically investigate, proving what were the injuries caused from the crash forces versus smoke and soot inhalation and blood levels that would suggest your client survived the impact and succumbed to the fire. So there's just tons of examples, and it really no substitute for getting in and getting a good biomechanic or a good forensic pathologist in the case of a death, and trying to figure out early on the front end, the automaker is going to deny there's a defect and deny the defect caused anything. So you really want to feel good about the damages and cause in fact that the feature of the vehicle or the failure of the vehicle is the reason for the damages that you have.
Well said. On damages, and kind of deviate slightly from the topic, but it's related. On your death cases, I mean, for me, one of the saddest things on the death cases is the moment before someone's killed, and if they had the fear, the apprehension, any conscious pain and suffering post impact, prior to succumbing. What do y'all do, Alan, on y'all's end in establishing what South Carolina calls survival damage? Those damages incurred prior to ultimately losing consciousness and passing on.
Well, they're super important for a lot of reasons in Georgia. And in a wrongful death context, in Georgia, we have two types of claims. There's a wrongful death claim that is a creature of statute that belongs as a matter of law to the people named in the Wrongful Death Act, which is a spouse and children, or if there is no spouse, children, and it ultimately flows to the estate and the heirs if there's no siblings, children, etc. But the other claim is for pain and suffering. It's the damages that belong to the estate. And the biggest component of that is pain and suffering, including pre-impact fright, shock, and terror, but also all elements of pain and suffering for as long between the injury or impact and the person passing away. So it's really important legally also, we have a quirky thing in our law. Punitive damages belong to the estate. So it is oftentimes a battlefield. If you have what on its face looks like a quote immediate death of, the subject matter of this is awfully macabre, but if you have an immediate death, the defendants will try to throw out an otherwise good punitive damage claim. Think of the best punitive claim you can think of, but then change the fact that the decedent, the injured party, was instantly killed. There is an argument that you cannot get punitive damages because there is no underlying compensatory damage to attach it to, because there's no pain and suffering for the estate claim, because the estate claim, the wrongful death claim, cannot legally be the vehicle to get to punitive damages. But
it's like legal fictions on top of legal fictions on top of legal fiction.
Right. It's really interesting. You can't make this stuff up. But it's really important. And so you start with getting a hold of, as quickly as you can, all sources of figuring out who was there, right? The obvious things are things like EMS reports, coroner, 911 calls you've got to get a hold of, body cam from police. The more the technology is advanced of what's out there on police cruiser cars and state troopers. And as you know, there's oftentimes multiple agencies that respond to a serious crash. So you've got to get their video, their camera footage, and really the names of any witnesses they recorded, any statements. And you want to get to those people as quickly as you can while memories are fresh, and you want to gather the story. What did they hear? What did they observe? And it's important to get to the details, because a lot of times, in my opinion, you don't want to lead with were they conscious or not. Conscious is a conclusion that, frankly, those of us who are not, including us, who are not medically trained, really don't fully necessarily understand what that means. I mean, you need it. So we're trying to get to very specific things. Was there movement? Was there sound? Were there words? Was there eyes fluttering? Those kinds of things. And you're trying to build that case to gather those facts as much as you possibly can. That can be a really, really, compelling and powerful part of a case. It's not just legally important. It's an important part of your client's story.
And you're right. I mean, it's terribly macabre. I mean, it's an awful, awful thing to have to talk about. I mean, the saddest part for me is typically somebody else, did it and will continue doing it, unless, the Alan Hamiltons of the world and others hold them responsible and obviously make a difference, and a bigger difference in the lives of the survivors, and give honor to the person who was taken. But it's awful. I mean, sometimes I remember years ago when my wife and I were first living together, she'd be like, "Oh, what'd you do today?" I'm like, "Oh, we did this, we did that." And within about a week of living together, she was like, I'm not going to ask you what you did today anymore. Like, I'm just going to ask you, how was your day? I was like, that's a great question.
Better question.
Better question. Shifting gears back to where we were in terms of identifying additional claims and aspects on auto cases. Talk to us about the DOT.
Yeah. So DOT in just about every state, pretty much any state route or federal interstate highway, your bridges, most roads except for your city streets are going to be governed by the state DOT. Ultimately, it's a lot of federal funding, but the contracts will flow from the DOT to both improve those roads when you see highway work going on, like literal repaving of lanes or expansion of lanes, or things like cutting grass. I mean, and trimming back trees and right-of-way maintenance. So we've dealt with all those kinds of things, and you need to. It's about figuring out the facts surrounding what happened so that you can triage your case. So I'll give you an example of this. We had a case on I-20 westbound outside of Atlanta. We actually had two cases that had occurred in the same construction zone. So we get we get the police report, and it really doesn't refer to the construction zone. So you've got to get out there, or at least get a hold of of footage. And I'll add this as a quick aside. Something we do in all cases now is immediately look for traffic and other surveillance camera footage. And we've always classically thought, okay, if it's an intersection and there's a 7-Eleven there, you want to get a letter to the 7-Eleven to see if their surveillance cameras on their gas pumps and their parking lot might have captured it. And that is still good advice. That's still something you should do. We've had many a case proven, and another blessing for a trial lawyer, sometimes a case we know is not a case before we've worked on it for 2 years from getting those kind of cameras. But what I'm talking about is more traffic cameras. And in Georgia, there's a specific service we go to immediately in every case. I don't have the website on the tip of my tongue, but if anybody wants to email me, I can get it to them. And probably are similar services in other states. It doesn't last very long. The stuff goes away pretty quickly, but it's remarkable how often we can get, particularly on the interstates and other major highways, cameras that actually show what happened in the crash. So that's a building block that you want to have. But in getting back to my story to illustrate the DOT front or angle here, we know only this. Lawyer calls us to refer the case, and of course there's $1 million limits policy on the truck. It's an 18-wheeler that smashed into a sedan that had come to a stop in traffic on I-20 at almost midnight, middle of the night. Truck driver is, according to the police report, reaching for his mobile phone. You know, you wish it was a FedEx truck in this case, and you'd never look at the DOT angle. But in this case, it's a single truck operator, really no valid angle to get beyond the $1 million policy. He doesn't have a proverbial pot to piss in or a window to throw it out of. So you have no choice now but to look for other angles. So we learned, we could see from the troopers' footage that in fact it happened in a work zone. So anytime you're around a work zone or leading up to a work zone, you want to be thinking about especially if it's a traffic related crash. I mean, it's, I guess, obvious if the crash involves equipment from the work zone, you would of course look at that, but it's sometimes below the surface. It's not the obvious. This is just unrelated to the construction tractor trailer going west and our client going west, and she comes to a stop in traffic and he hits her at crazy high speed. Of course, him reaching for the phone is a cause of distraction, but we went much deeper than that and asked, well, why did all the traffic come to a stop in the first place out there that late at night? And why why was he looking away momentarily enough to cause this deadly crash? So what we discover about these things is in DOT cases, if you have a lane closure, so if they're doing work on the interstate and even sometimes right-of-way work, if they're closing a lane, they have to have permission from the DOT to do it. And then you have to, in any one of these construction projects, you're going to need to learn about something called the Manual and Uniform Traffic Control Devices, or MUTCD.
I was hoping we were going to hear MUTCD.
Wait till you hear it.
That.
Yeah, MUTCD, and then there will have to be a traffic control plan that's supposed to be really specific about what should be out there, and the budget, the contract documents will lay out what they're being paid for and thus what is expected. So our case was actually pretty difficult in the sense that they had a traffic control plan, and the major elements of it, at least those required by MUTCD, they were following. So then what? The next layer down is what was their particular agreement and what does some industry standards outside of MUTCD, for example, things like AASHTO, did those things tell you about how to operate a closure? And so in this case, they had hired off-duty PD to sit with blue lights flashing during lane closures. So it amounts to being able to prove that the construction caused the lane closure caused the backup. Well, that alone is not, that's true, but not by itself illegal, right? I mean, if they're allowed to close a lane, then you're closing to one lane. So you may stop traffic. There's no strict liability for this. So our case ultimately came down to where they were putting the blue lights. And the basic logic is the blue lights are there, especially at night, to grab attention. to tell you something's happening. It's not business as usual. We're not just going to keep cooking at 70 miles an hour. And even though you see all these orange diamond-shaped signs that say road work approaching, 1,000 feet, 2 miles, 1 mile, you can be kind of lulled into complacency, especially at midnight, and traffic's flowing just fine. You're still going 70 miles an hour or 65 or whatever with the flow of traffic. And then all of a sudden things back up in a very quick way. And part of that, we believe, and this, the evidence and the industry standards and studies supported us on this, is because you don't have your advanced warning blue lights placed in advance of where it's backing up. Like, you're not warning people with the blue lights, grabbing their attention to get them out of the complacency of being in the flow of this work zone. And so that was an important component of that case. And we were able to do, multiples better than the insurance that was available from the truck by working that case, a tough case, but working that case hard for several years.
Tough case. That's good work. Yeah. Really good work. In a case like that, who have you seen the typical defendants are beyond the DOT?
So it's going to tip, if the traffic control plan is being followed, it's probably going to have to be, if you're just saying the plan itself is deficient, it's largely going to be the contractor. In fact, the DOT itself is subject to we could do a whole nother podcast on the Swiss cheese of immunities and tricks and traps for getting to the DOT. And even if you do get to the DOT, it's a limited recovery, at least in Georgia. So it's, in a lot of situations, better if the facts really point to the contractor to just go to the contractor. I'm sure you're familiar, there are oftentimes construction, engineering, inspection, or CEI firms that are also contracted for jobs. Their job, in a broad sense, is to make sure the contractor is doing what the state's paying them to do. So if you have a deviation from the plan, you may have a CEI case, because the CEIs it's interesting. They get paid a bunch of money, but when you sue one, they're not responsible for anything. They don't know nothing about nothing. But one of the things they are hard for them to dodge is they do typically are supposed to go look and make sure the barrels and the signs and traffic control plan that on the ground matches what the plan is in the contract set. So you got to look at that angle as well. But the first place you typically would turn is just the contractor. If you're saying, look, the actual the way you were doing the job of managing traffic is out of compliance with industry standard and therefore negligent.
Great practice tips. Great practice tips on work zone cases in particular. Let's move to repair shops.
Sure. So one of the things in a case, and this probably is more, it can be a crashworthiness case or a defect that causes a crash case. You gotta look at, a lot of times this is when you're concurrently looking at suing an automaker. So let's say I had a case recently, Chris Glover, a dear friend of mine, and I had different clients in the same case. So he and I worked this case. It was a 15-passenger van that tipped over and caught fire. Well, 15-passenger vans have a long history. 7 women died in the fire, and like 8 others were hurt in varying degrees. So between the two of us, different lawyers had referred all of either him or me, all the cases. So a lot of people were involved, but he and I were working on it closely together. And so we knew from the history of 15-passenger vans, which is its own fascinating story, they're very, very rollover prone, because back in the day when they were created, the automakers basically took the same chassis of a shorter van and said, this would be cool. Let's just take the same track width, the same chassis, and let's blow the back out a few feet and throw a seat back there. And when you do that, especially when you load the van, when you put it full of 15 people, as the name implies, a 15-passenger people mover vehicle, you move the center of gravity up and back, both of which are very, very bad for stability and handling and rollover reduction. So it actually, in the early 2000s, the federal government came out and recommended automakers stop making these things. And they did. I mean, if you see one of these vans now, a more modern iteration of it, it's a fundamentally different vehicle, not just with electronic stability control, but the way it is built compared to what they used to be. So we knew this was an older van. We knew there was, good evidence, these kind of cases. There were a number of these that had happened before, but we're unpacking everything because you have to know if you're looking at an auto product case, you don't want to overlook a finger they will point at some repair shop that may have screwed something up. So one other thing you have to look at, particularly in a rollover case like this, is the tires. The tires are the only contact of the vehicle with the road. And especially if you're looking at a loss of control case or a rollover case, you want to evaluate and closely inspect the tires. Well, we did not have a classic tread belt separation in this case. So it wasn't a failure of a tire in the classic sense, but we wanted, like we would in any of these cases, to get from the owner of the van all maintenance history and records. So typically they're not going to have everything, but they typically will at least have something in the glove box, some receipts. And this was a business owned this, so that gives you a better chance to piece it together. Sometimes though, if it's your own client's vehicle, obviously it's easy to have the conversation pre-suit about where did you take this thing? And then you want to get requests out to get a hold of those records. And in our case, we initially just filed suit for purposes of getting this discovery. Obviously, the owner of the van, they're relatively modest insurance. They would have fallen all over themselves to pay that, but we needed to get discovery. So we were able to get discovery from various different shops they had taken the vehicle to. And when we inspected the tires, we learned that the tires were the wrong load range. So you have to become a little bit of an expert in these cases of understanding what the specs on a tire are, not just, you can find out a lot from the DOT number, but what are the other things on there? There's the physical size, and then the end of the specs number on there is usually a number or a letter that represents a load range. What is a load range? That is how much weight, how much load the tire is built to carry, with basically how sturdy is its construction. And we learned that somebody had put tires on this vehicle that were too light of a load range for what the vehicle called for. So you might say, well, what do you mean? How do you know what the vehicle called for? Well, that information is on the placard. So if you open the door of any car, or you just look it up in the owner manual, as in our case, the door was burned beyond recognition. So we had to go get an exemplar to cross-check it, and then also get an owner's manual and cross-check it. But the vehicle manufacturer tells you about any car in those places what size and load range and speed index you need for that car, and what pressure what cold air pressure those tires need to be inflated to, because the tire is the connection to the road, and its performance in terms of handling and stability is directly tied to having the right structure and pressure to give back what you need. And if you don't have, in our case, this vehicle, these tires were only capable of being inflated to 44 PSI, because I'm throwing a lot of tire lingo out, but the max air pressure on the side, we look at this case and it says 44 PSI. Well, the automaker for this van had called for 80 PSI on the rear. So the tires on the rear were these max 44 pressure tires, and of the wrong load range. Of course, the load range is directly related to how much pressure it's designed to hold. So we now have it's a problem in the sense that we've got to decide, is it the bad van, or is it the wrong tires?
You
Or is it
answered my
both?
question. Yeah, I mean, that was going to be my question. I'm like thinking, man, repair shop screwed up, bad tires, but God, now we got this manufacturer. So keep going.
And when we had an initial extra problem, the tires it turned out, were installed by a franchise store of a big brand. So the big brand would be a very viable target, the franchise store had very limited coverage. So, in the context of talking to a plaintiff lawyer audience, of course, that matters, as we all know. I mean, we have to discover what the truth of the matter is going to be from an engineering standpoint. But at that early stage, we're also, let's call it, motivated for it to be more about the van than the tire. But we decided, and I think wisely, that we ought to find out from testing earlier than later. So these cases can be and are really complex and expensive, but also fun, because you get to go out and do things like put outriggers on an exemplar and put all kinds of instrumentation on it and put weighted water dummies to try to replicate the loading conditions as best you can for who was in it, and then run and then figure out what maneuvers do you want to run. And you need to learn how do automakers actually prove out handling stability. What tests do they use in order to study the handling characteristics of the vehicle? And one of the big things in rollover is all vehicles are designed to understeer. So if I do something stupid and I yank the wheel really hard, the vehicle should not steer. When the tires saturate and they can no longer track what I'm trying to put into that steering wheel, the vehicle should turn less than what I put into the wheel. The real problem with rollover comes when a vehicle oversteers, so that I put the wheel this far and the tires, in this case, one example of a cause of oversteer is when the tires don't have sufficient stiffness from a combination of construction, wrong load range, and lack of pressure to respond. The vehicle, the front tracks, and these wrong load range on the back do not. And now the vehicle has steered more than I turned the wheel. That's an oversteer, which can put the vehicle into that turning or spinning condition that we call a yaw. And that's not good. That is no bueno. And that's what happened in our case. So what we needed to figure out was, well, what kind of loading did this van experience in the real world? So if you have a really good reconstructionist and you have some decent physical evidence, you can map the path that the vehicle actually took and where it rolled. And once you start to tease out the variables, how fast it's going when it rolls, you can then approximate the G forces, the lateral acceleration, or the G forces the vehicle's undergoing. And then you can ask, well, would the vehicle with the right tires have tripped up under those G forces? So you can run a test, which we did, where you run the vehicle in a circle with a steering machine with outriggers on it, so it won't actually roll over and destroy your exemplar or mess up the equipment. And you can measure the lateral acceleration, and you see how long will this vehicle stay on the circle, and when it goes off the circle, will it understeer what it's designed to do, or will it oversteer? And also, relatedly, will it tip up? Will it roll? And so, interestingly, in our case, we found that the vehicle would not oversteer with the correct tires on the back at the correct pressure. And it also could just handle the G forces that were involved in our crash. But when you put the wrong tire on, lo and behold, it turned over. So we had, an interesting finding there that suggests, is it a bad vehicle? Yeah, it's a bad vehicle. Was our view, still is our view. But does it also have a significant relationship to the tires? And the answer to that was also yes. So, it's a whole, was a really interesting case, and really on the complicated end in terms of the engineering and the science and what the various causes were. And then we had, in this computer age, don't despair if you have a franchise store. There are, the franchisor defense is really tough in the classical sense. It's very hard to just say, Chick-fil-A, you're responsible for your franchisee serving bad fries because you control them. That's pretty much a dead end in Georgia. There are tons of cases where people have just tried to charge up the hill. What do you mean they're not yours? They're wearing your uniform, serving your food at the temperature you say they have to. And it's the same way with a big chain tire store. They're subject to all kinds of policies and procedures, but generally speaking, the courts will just whitewash all that and say, it's just They're just, ensuring compliance with the contract. That's not controlling the time, manner, or method of the franchisee's performance. So I would recommend anybody looking at that, don't give up, because what we found was we wanted to get to, well, how the hell did they sell them the wrong tire? Like, what happened? It's a pretty egregious mistake. And so what we were able to tease out was they used a franchisor, big chain, provided search tool that they didn't have to use it, but it was encouraged and provided to them, and they were trained on it by the franchisor. And by the way, the guy who ran and owned this shop had never even been in the auto repair business. A lot of these chains, they want to develop these franchises. If you got the 60 grand and you'll go to their 2-week training wherever they do it, they're going to slap you in business as a store. And you're expected to then go out and, I guess, hire a mechanic that knows what he's doing. But in some of the depositions, I said, well, I run a law firm, but if I didn't know how to practice law, it'd be awfully hard for me to hire a competent person to do the legal work. If I don't know what the hell I'm doing, how am I going to hire somebody to know what they're doing? Just as a simple analogy, but laying that aside, that played into the fact they were using this tool provided by the big brand, the franchisor. And it turned out we got access, we demanded access to that password protected site they used, and we searched our vehicle and we held our breath, and lo and behold, the wrong damn tire popped up on the screen as one of the recommended options for the van. So from there, the case took on a whole different turn and tone, and we were able to really have a direct negligence theory against the franchisor as the direct cause of this van that belonged to this nonprofit drug recovery center going out and being on the road in a deadly dangerous condition, basically just waiting for the moment where a driver needed to make an evasive maneuver.
That's great work. Really exceptional. One of the things that stood out to me while we've been talking is it's the same emphasis that we try to place on, like, all right, why the hell that happened? How the hell did that happen? Digging in. And typically, as you've seen repeatedly, and as you've described on the podcast, the bigger the catastrophe, usually kind of the more egregious the answers to those questions of why. And in this particular instance, what was the why behind the wrong tire being listed in that software program by the franchisor? Just out of curiosity.
There was not a good explanation for it, but we bear down on that very, very hard. And one of the key admissions in the case, ultimately, when we deposed the corporation in a 30B6 deposition, we went in. Their position was the store screwed up. This thing is not designed to be a tire finder. The store is trained on, and they know you have to go look at the placard. All this search tool is an inventory management tool. Like it's just to tell you what tires like physically fit the rim of your vehicle. You are supposed to then go make sure you're selling one that has the right specs, like that has the proper load range and matches the vehicle's placard. Well, the problem is they called the thing an advanced tire search tool, and it had, like, in the manual for it, it said, we'll find you, just put your vehicle make, model, and year in, and we'll find you the right tire for your vehicle every time. And interestingly, this big company had a public facing site. So this site that the franchisee used to get the wrong tire was a password protected only for people that signed up for this service. And then they could order through it and the tire would show up and all that. But the public facing site, if you went to and search for a tire, as if I was Joe Consumer and I wanted to go to one of their franchise shops and buy tires, before I go, I could search their tire inventory. That site would not it would not display to you or allow you to pick a tire that was the wrong load range. So that was tough for them to explain, but they basically were trying to say, well, that's for the public and this is for dealers. They're supposed to know better, right? These are auto professionals that are trained and running their own store, and they're independent of us, and they're supposed to check the placard. And like a lot of things, I mean, it is true that you would expect, and I'll mention as an aside, another big chain after the fact serviced this vehicle and didn't notice it had the wrong tires on it, even though they should have noticed. That's not as egregious as the original sin, right? But even if you're most of these stores, you want to look at their policies. They even if you're in for service, just as an aside, this is important as a practical pointer. If you're in for service somewhere, you want to understand what the courtesy inspection policy of that provider is, because you might look at it and say, oh, well, I can't make a shop case out of this because, yeah, I've got a tire issue here that contributed to my crash, but that shop just saw them to do an oil change or to do lube and filter or whatever they may have or work on the transmissions. They didn't get paid to and didn't do tire work. Well, it's a sales opportunity. I mean, so therefore most stores, certainly bigger box stores, bigger branded stores, will have pretty extensive policies to train their franchisees how to sell. And part of selling is making sure if I come in because my wiper blades are bad and I have bad tread on the tires, you want to tell me that, because is it the right thing to do? Yes, but also it makes money. So they'll actually have good policies on that. And so we had that in our case, and we had various other defendants. Sadly, the last of the defendants to touch the vehicle was a mom and pop that didn't have much coverage. So we could have another podcast about all the strategy of how those aspects of the case go. But you got to look at all those things and don't just assume that because they didn't service the issue that you have, that the shop, have no responsibility for it. But kind of getting back to your question, why we got down there, and at the end of the day, they said it's not for this. So we got the instructions out and said things. Well, don't you agree with me, sir, that it's incomplete and misleading to not tell them that the load range on these tires in your search tool is not right? And he paused and he goes, I'll agree with the misleading. I was like, okay, that's good enough for me. So we had some good moments like that, where really by peeling back the layers of the onion all the way to the core, there's sometimes just no answer for it, no good answer. And I couldn't come up with honestly a reason. Well, we tested or kind of focus group. We all know this plan, but the first thing you're looking for, and it's just usually true as a matter of human nature when you're talking about big companies, follow the money, right? So what's the profit-seeking reason to have the site do this? And it does make sense on its face that if you don't limit the universe of tires you display, you increase your chances of making a sale, because you're always going to have something that fits the rim. Whereas, theoretically, you might have a situation where you didn't have the correct load range, and so you wouldn't be able to make the sale. But there's so many tires out there, just us talking, we didn't really know if that carried water. And our credibility is so important. I won't make an argument in court that I don't really believe. It's really pretty simple. If I think it's going to come across as an exaggeration, that's death to a plaintiff's case, because my credibility is all I have. But so at the end of the day, this was truly the other option is it's just sloppy. And I think this boiled down to sloppy. But even then, the beauty of it is they won't say that. So you just keep pressing them until they're.
Yeah, they didn't say in the first 30 minutes of the deposition, hey, Alan, it's exactly what it looks like. It was a screw up on our part. Shouldn't have been on.
No, they didn't say that.
Question just as a practical matter, the cases we've talked about, I love that they all kind of make sense. Like one of the things I do really enjoy about the sciences, be it medicine, physics, engineering principles, is they make sense. Like stuff works together the way it's supposed to work together. And typically when something goes horrifically wrong, it's because, the humans involved threw off the way it's supposed to go down. As a practical matter, though, what does your team look like when you're approaching these things? In other words, like you mentioned on the bus case, you had a colleague and y'all were attacking it. together. But for the folks at Shiver, Hamilton, and Campbell, or is it you and one of another lawyer from the firm and a paralegal? I'm just trying to get an idea in the sense of who's responsible for what, because we're talking about expensive, time-consuming, hard cases. So what does the division of labor really look like?
Yeah, so it's first of all, whoever makes, and we're a firm that doesn't recognize. One of the things I love about my firm, I've been with Jeff for so long. We don't recognize like I generated this case, so I get more money. It's not. I love that. It's not a money thing. It's just if the case came to me, I get first dibs to work on it. And the same with one that Jeff generates. Although we also kind of have our own little areas that I've done more of these types of complex, whether it's a DOT case or I've got a right-of-way cutting case right now where a bush hog shot out a piece of rebar that it hit and killed somebody. So those kind of cases are typically going to move their way towards me being involved. But we put, and there's other things that Jeff, for example, like negligent security, he's just such a guru at that. Even if I have one of those that comes to me, he's going to very often be involved in it.
Yeah, for folks who aren't familiar with Jeff Shiver, check out some of the things he's done in the negligent security world.
It's remarkable. Again, he had a big verdict on a fire case with a boarding house that was out of code last year. So largely like premises stuff is going to be Jeff. But forget that for a minute. I mean, really, we'll have somebody that's the senior point of the spear, and then we'll otherwise assign either at least one other lawyer, sometimes multiple other lawyers, to sometimes research legal issues and or kind of run the fact finding part of the investigation. Always we'll put a paralegal on it, but we don't believe in silos generally. I mean, there's lots of ways to run a firm, but I like continuing to be, we're now in our 14th year. So I think part of the secret sauce of that has been to not become like a bunch of little fiefdoms. Well, okay, well, that's Jeff and Jessica's team or Alan and Chloe's team. It is really one big team where we put together the case team based on what the case needs.
Awesome. Man, y'all just do again such great work. And it's the more I practice and the longer we've done this podcast in particular, you just see that oftentimes the best of the best haven't had anything handed to them. Like it wasn't like these cases came into y'all on a silver platter, ready to go. The last guest we had right before you, Alan, was Zoe Littlepage, and she had a line that stuck with me ever since. She said, "It work is magic. What we do is alchemy." And the idea that magic and is really being created. We're creating something from some of different parts through an amazing amount of hard work and y'all's the examples you've given speak to that. So I commend you as a colleague.
Appreciate it. I should say my favorite cases are the ones that are, truck with a ton of insurance ran a red light, and those we certainly do those too, where it's, I always like to say I like cases where my fifth grader could settle it for $5 million and somebody's calling us to, go get 50.
Wow.
But you really, you have to be, I think you get better at, no case is truly easy. And I think that doing the really hard work helps you even in the ones that to actually max out the ones that on their face, you could just kind of lay up off the glass and get good money for.
Yeah, I mean, the tagline I came up with, because it just hit me, I was like, what are we really doing? Well, hell, man, we're working to make good cases great, and you got to work hard. You can have a good case, but you want to make a great case work.
Yeah.
Listen,
Yeah.
thank you so much for coming on. This has been fantastic talking with you. For folks who want to get in touch with you about auto case, about construction site cases, explosion cases, these catastrophic single event cases, be it in Georgia or anywhere in the United States, what's the best way for them to get in touch with you?
Yeah, email Alan, ALAN, at shiverhamilton.com. My cell phone is 404-936-5569.
Great, man. Thank you so much for coming on, and good luck to your Auburn Tigers rest of the way, my
Oh
friend.
man, they're going to need it. It's been tough.
I think folks who listen to this know I'm a Clemson fan, and we're recording this a couple weeks before the Clemson Carolina game. It's going to air after that game, and I am not hopeful. It ain't looking good until
Good luck.
we
Yeah.
go to revenue sharing and away from
Well,
NIL, because we have not adapted. So, anyways, man, always good seeing you. Thank you for coming on.
likewise. Thank you. See you, buddy.